Hi, it's Mike DelSignore here. I want to talk about what happens if you have an OUI charge and your case is going to be heard in the Palmer District Court. If your case is going to be heard in Palmer, keep a few things in mind. That's a really good court. The judge is good. Things are treated a little bit differently. If you watch some of my other videos, you might be able to get a more favorable resolution in that court prior to trial. So in Palmer, sometimes they'll negotiate. They don't generally negotiate OUIs in, say, Rentham, Attleboro, basically anywhere but Western Mass and Martha's Vineyard in Nantucket. There's pretty much no negotiation. But in Western Mass, sometimes they'll reduce an OUI to negligent operation and let you plea out the negligent operation case. I've had a couple of dispositions like that in Western Mass or courts like Gardner. So courts, there's select courts where that can happen. That's one of them. So keep that in mind. Good way to potentially resolve an OUI without a conviction, without going to trial. Now let's talk about what typically happens. Normally, if you refuse a breath test, you're looking at a 6-month suspension. That's a good case to take to trial. There's a good chance you'll be able to win the case because there'll be no objective evidence of your blood alcohol. The case will depend almost entirely on field sobriety tests. These tests can be inaccurate, unreliable, and sometimes there's other explanations for why you didn't do perfectly on the test other than alcohol. Many cases, people have bad balance. They might be tired, nervous, might not understand the instructions. Sometimes the offices, and this is coming up a lot in recent videos, they have you do the one-leg stand. They're telling people to stop before they're even putting their foot down. So they're cutting you off before the test is even done. So these videos reveal a lot of things that happen that don't make the report that show you really weren't impaired. With the videos, I like to break up times where I can say, geez, my client stood there for 12 seconds. He was fine, no problems with balance. So it gives us a new way to talk about the case, a different way to frame the issues, stuff that's not in the report, not going to be on cross-examination, that can't be denied. And sometimes the officer won't remember. Sometimes they will. When you show the video to them, they'll acknowledge that on the stand. So I handle these cases all over Massachusetts, do OUIs, work every day. So for refusal cases, strong cases for trial, you sometimes can attack the basis of the stop. I had a case in Palmer once where the stop was declared unconstitutional, third offense, dismissed. If you took a breath test, don't feel as though you can't win the case. If the breath test can get excluded from evidence, they got to prove that they complied with certain procedures to get the test into evidence. And that can be done. I've had a lot of success doing those types of motions. The benefit, if you took the test, is you can get your license back in 30 days, so you can drive while we're fighting the case. So your life won't be as affected as if you refuse, because it's only a 30-day suspension. Of course, if you are found guilty, whether of refusal or an OUI, you're looking at an additional 45-day suspension. When any of these license suspension times are up, make sure you request a hearing about 3 weeks prior to the date so you don't wait any additional time. Very important to keep that in mind. So if you have questions on anything related to OUI, feel free to call, text 781-686-5924. My passion is helping people charged with OUI make the best decisions for themselves that they can on these cases. So for many, that's to take the case to trial. Is not a huge difference between a guilty and a quaff on an OUI case. On a first offense, most judges will impose basically the same resolution as if you lost after trial. So generally no trial penalty here in Massachusetts. If you're looking at a second or third offense, things can be different. But what will happen is on your first offense, you'll go to court, you'll enter not guilty, you'll get an arraignment. In the case, generally they can move pretty quickly towards a trial. If there's a motion, if there's a legal issue, like I was mentioning before, where the case with a stop, we had to challenge the stop, that will require an extra date. The case might take a little longer scheduling the motion, but generally we can go from arraignment, pretrial to trial. Sometimes there's an extra pretrial thrown in if the DA has trouble getting discovery. But you're nervous, you're scared, you don't know what to do, feel free to reach out. I help people every day. I'll give you straightforward advice. I tell you like it is. Don't make it better, worse. You're not looking at jail time on a first offense. Generally, even a second offense, you wouldn't be looking at jail time. But certainly a second offense, it's more likely. But a first offense, typically somebody wouldn't get punished for going to trial. So jail is not a serious risk in most first offenses. So questions, call, text, anytime, here to help you. It's my passion. I've been doing this for 20 years. I love helping people make the best decisions they can for their case while being in court, standing up for somebody arrested for OUI and representing them in court. I'd be glad to help you with your case, whether in Palmer or at any court throughout Massachusetts.